All right, court's now in session. I will be Sasser presiding.
All right, good morning, everyone. People are welcome to sit in the jury box. I don't want to have anybody stand. We're covering Judge Curley's cases. We have all the foreclosure cases as well. So thank you so much. I'm going to see if we have Judge Curley's cases. Michelle is not here yet. All right, so hold on just a second. Let me go ahead and I'm going to call out Judge Curley's cases. Hine versus Lewis. Anyone here in Hine versus Lewis?
I'm here on that.
All right.
Morning, Judge.
Good morning, guys. We have a court reporter. Nice to see everyone. Good morning. If council could please state their appearances for the record.
Harry Wingerman for the plaintiff.
Basic Court, Your Honor, Bill Fleck here for Lori Lewis, the defendant.
All right, good morning. It's nice to see both of you this morning. This is Judge Curley's matter. It is a motion to dismiss and or strike amended complaint and a motion for protective order. Mr. Winderman, I had an opportunity to read both motions. Would you like to proceed with argument, please?
The motion for protective order was resolved by an agreed order of the parties.
Excellent, good. Okay, now, so we just have a motion to dismiss.
Yes.
Judge, these are my motions.
Oh, okay, that's fine. Go ahead, you may proceed.
Thanks. I didn't notice this.
Oh,
Mr.
okay,
Winterman did. He believes it can be dealt with at a motion counter. I don't think so.
okay,
And I specifically filed a notice of objection indicating that it's a verified motion to dismiss or strike as a sham pleading,
okay.
which requires under 1.150 an evidentiary hearing.
You're correct.
Judge Curley's divisional order says it has to be an evidentiary hearing.
Okay,
The cases that I cited, one of which is the 4 DCA, require it under risk of reversible error to be an evidentiary hearing.
correct.
So I think we need to have an order entered directing us to set it for an
That's
evidentiary
fine.
hearing.
Can you go ahead and please do that in front of Judge Curley?
If I may, Your Honor.
Sure.
It is a motion to dismiss and a motion to strike.
Well, he's doing both in it's the alternative.
Right. The motion to dismiss should be heard. That doesn't require an evidentiary hearing.
You want to proceed with the motion to dismiss? Or do you want- I mean, it doesn't make any sense to do it piecemeal, so I think you should do both. You should be able to get into Judge Curley pretty quickly. So,
And the problem, as long as this court will enter an order requiring Mr. Fleck to agree to a hearing date within the next 30 days.
yeah, I'm going to respond.
Thank you, Your Honor.
I gave you a proposed order, Judge. It says we'll refer, we'll get it specially set. You can just add that additional language.
That's fine. Let me go ahead and give this. You guys can fill it out and hand it to the bailiff.
Thanks, Judge.
Have a great day. Nice seeing you both.
Thank you, Your Honor.
All right, let's please do Judge Curley's case. Wilmington Trust versus Singh, please. Counsel ready on that one? Anybody here on Wilmington Trust versus Singh? No? Bethel versus Nixon. All right, come on up, guys. All right, good morning. Is the other side here?
No, they're not, Your Honor. I just heard this morning that they won't be attending.
Oh,
They've
okay.
agreed.
No
So
problem then.
It's just a
It's your
motion.
motion to be excused from the portion of trial docket, and I'm going to grant that motion.
Thank you, Your
That's no
Honor.
problem. Just hand the order to the bailiff then.
Okay,
Thank you so much. Have a great day.
you too.
All right, let's go ahead and do Brighton at Century Village versus unknown heirs, please. Motion to disperse surplus funds.
Good morning, Your Honor.
Good morning. This is Judge Curley's case.
Yes, Your Honor.
Is there any objection?
No, and there's been no other claims on the surplus. On the current, there was a surplus of $3,954.83. We're only looking for $2,220 and 60.
Wonderful. I'm going to grant that. Just hand the order to the bailiff.
Thank you, Your Honor.
Thank you so much. Have a great day.
You too.
All right. Let me also do Judge Curley's case. Deutsche Bank versus Garin. Anyone here on Deutsche Bank versus Garin?
Yes, Your Honor.
Okay.
This is the defendants. Just to confirm, Your Honor, Carolina Warren.
Yes, Garin. It's 2007-14115.
Yes, it is actually a defendant's motion.
The defendant's not here. Motion to cancel.
It's an agreed order.
Okay, that's fine. Just hand the order to the bailiff.
Thank you, Judge.
Thank you so much. Have a great day. All right. Cohen versus Lakeside Development. Council ready? Good morning. Okay, wonderful. All right, good morning. Nice to see you guys. We have a court reporter. If council could please state their appearances for the record.
Yes, sir. Here on behalf of the plaintiff.
Dan Rice on behalf of the defendants. Your Honor, we're here today on the defendant's motion to strike who's expert, but
Mr. Zimmerman, yeah, I read the motion.
in light of the double docket, we're willing to just go ahead and read a special sentence.
Is that okay? That's perfect then. Just put that in the order and then you guys can special sentence. Thank you guys. Have a great day. All right, let's please do Duffel versus Indeed Properties, please. Motion for default final judgment. Good morning.
Your Honor, I have the default packet
Yeah, just hand everything to the bailiff, please.
as well as the proposed order.
Thank you so much. Have a great day. All right. Anyone here on Judge Curley's Wilmington Trust versus Singh? We're still waiting. Okay, I'm going to start calling out the foreclosure case management conferences. First of all, is anyone here on the 8:30 for me? Scott versus Doggard. You guys ready? Let's do it. Let's take care of you guys. I've been waiting very patiently.
Good morning.
Good morning, guys. Good morning. This is Scott versus Duggar, and this is the motion to strike. These are all the affirmative defenses. I always need to ask council, have you had a chance to discuss the affirmative defenses
I
here?
have somewhat. There were 4 that were withdrawn, and there's 4 that we're going to proceed on
Okay,
today.
that's fine. I didn't know which 4 were remaining.
Yeah, the 4 that remain, I believe, are 2, 3, 8, and 11.
Oh, okay, got it.
2, pardon me?
1, 8, and 12.
Which one's remaining?
I believe it's 1, 8, 11, and 12. Please double check. So just scribble down the numbers. Okay. All right, Your Honor, we're ready to proceed.
Okay, that's, which ones remain?
1, 8, 11, and 12.
Okay, 1, 8, 11, and 12. All right, let's start with number 1, please.
That was withdrawn.
Oh, well, you guys are not on the
Still
same
with her,
page.
'cause I'm
Do you guys,
reading the
let me,
wrong
which
numbers.
4 are remaining?
Okay, Your Honor, the plaintiff moved to strike.
Do you guys want to go outside and see if you guys?
No, we're ready to
You ready?
proceed.
Okay,
I
that's
think we got our numbers mixed up.
Okay, that's fine. We're having different numbers here. It's like bingo.
We're going forward with 2 and 3,
2 and 3.
and Fabre defense.
Okay, got it.
And the alcohol
Okay,
defense.
all right, so let's start with number 2.
All right, 2 or 3 are somewhat the same
Yeah.
argument, Your Honor. And I think we're arguing 2 sides of the same coin. We're saying it's legal conclusion, they're saying it's factual determination. The real issue is whether it's an affirmative defense.
I agree. Remember, an affirmative defense is a yes, but. How is this a yes, but?
Well, Your Honor, we argued that, that this is a factual,
But that's not a yes,
determination by
but.
the Jury.
Factual determination is not a yes, but. That's, I agree with counsel, it's not an affirmative defense. So I'm going to strike those with those. Let's do the next 2.
The next one, Your Honor, is the Fabre issue, and I
Oh,
know
sure.
you see this quite often.
Absolutely.
There was no identification of the party.
Under Nash, yeah. Yeah, we need the party under Nash.
Your Honor, an affirmative, first of all, we raised this affirmative defense in order not to waive it. because it
You
is-
won't waive, you can always move to amend. So I'm going to grant the motion to strike. You can always move to amend, but under Nash, you have to specifically name the third party.
Your Honor, it was my understanding that under Nash it needed to be done prior to trial and.
You can always move prior to trial. We're away from trial, so you can always move. Motion to strike is granted.
Right, Your Honor. The final one is probably the more complicated one because it's not.
The alcohol defense,
spelled
yeah.
out real clear. But this is a dram shop case. First, Your Honor, it would defeat the entire purpose of dram shop to say that the person's intoxication is a defense to a claim that's based upon.
But why, that's a statutory defense. Why can't they use that?
Your Honor, because it's, like I said, the 2 working together would cancel out the existence of the cause of action. It's a requirement for us to prove this claim that the injured party be intoxicated. If that
I know.
intoxication then defeats
Is
the
there
claim.
any case law on this issue?
There is, Your Honor, and this is why I was saying it's somewhat, and if I may approach and
Sure.
Raji with Q versus L House
Sure.
Management.
Let me take a look.
And this was a case where, a dram shop case where it was, the defense, the alcohol defense was raised. I've got it highlighted there on the first page,
Okay.
out that his blood alcohol was in excess of the limit. They brought suit against the L House, claiming they breached the duty under the Dram Shop Act by selling a certain amount of alcohol. And they raised the defense. And the underlying summary judgment, counsel's correct, the underlying summary
Shouldn't this be a
judgment.
summary judgment, not a motion to strike? It sounds like a motion for summary judgment disguised as a motion to strike.
Well, not necessarily, it's whether or not that defense is going to apply, because that's going to affect.
It's a legal determination. But why don't you re-raise this as a summary judgment? Because I don't want to, because there's case law that says you cannot use a motion to strike in lieu of a motion for summary judgment. Because I can't make a legal determination
I
on
don't
motion to
think
strike.
you're gonna need to.
No.
If you'll just
Sure.
turn your direction to the 3rd page of
Yeah.
the case that I provided you.
Okay,
Because I think this was addressed under the Tipsy-Coachman doctrine,
okay.
in that name. In this case, they raised the defense. It wasn't an issue on the appeal, but they tried to make a Tipsy-Coachman argument, saying, listen, we raised other issues that even if this grant wasn't proper, there's other reasons why summary judgment should have been granted.
That's what I'm saying. I think this should be a summary judgment argument. Why don't you just re-raise your motion as a summary judgment? I feel much more comfortable for appellate purposes than simply striking the affirmative defense. That's my concern. I cannot use a motion to strike in lieu of a motion for summary judgment.
Well, I'm not sure.
Because you're asking me to determine a legal sufficiency of an affirmative defense, right?
I'm asking to determine whether or not this affirmative defense exists in this type of action.
That's a legal determination. I cannot do so on a motion to strike. You have to raise, just re-raise this as a summary judgment. I can't strike the affirmative defense.
Right, and you're, just for the record,
Legally, I can't strike an affirmative defense. You're asking me to determine the legal sufficiency of an affirmative defense, which is a motion for summary
I'm
judgment.
not asking you to look at any facts in this
That's
case.
not a fact. Even a legal determination is a summary judgment determination. You're asking me to determine as a matter of law, it's not a valid affirmative defense in these situations. And I can't do so on a motion to strike.
Okay, can I just state this quotation?
Even this case talks about a summary judgment,
Well,
right?
it doesn't talk about summary judgment in this context, and there's only one sentence I really want to
Okay,
point out,
sure.
Your Honor, and that's it.
Okay, motions to strike is denied. Just bring it as a motion for summary judgment. Have a great day.
Your Honor.
Thank you. All right, if you guys can hand the order, we have an agreed order for Judge Carly, Bay Reach Condo versus Morrissey Real Estate. Agreed order, Bay Reach versus Morrissey? Okay, that's fine. If you have any agreed orders, you don't have to stay, just hand them please to the bailiff. All right, Wilmington Trust versus Singh. All right, I'm gonna start calling out my, my foreclosure case managements. And I'm just gonna call them in order, one at a time, okay? Because it's 8:45. First one I have up is Parta Polippo versus American Bakers. Anyone here on that one? Here, Mark, can you hold on, this is a new order? Just hold on to all these orders. Okay, perfect. Here on that one, Parta Polippo?
Yes, Your Honor.
Wonderful. What's the status of the case?
Okay, Your Honor, just let you know that plaintiff is sponsor, transfer her telephone.
Okay, I need the phone number.
Sure. Phone number is 301
301
943
943
8088.
8088. Okay, let me give them a call.
Good morning, Mr. Matt.
Oh, good morning. This is Judge Sasser. I'm calling you on Parta Polippo versus American Bakers. What's the procedural status of the case, counsel?
I'm sorry?
What's the procedural status of the case?
We're moving along. We have a mediation calendar scheduled for March 14th, and then we have 2 depositions coming up in April, one being of the plaintiff and one being of the defendant's field adjuster.
Wonderful. Are you guys at issue?
Yes, Your Honor.
Yeah.
Okay. Can I set you for trial?
Yes, you may.
Okay, how much time for the trial?
Your Honor, based on the calendar in our office.
3 or 4 days. 3 or 4 days for the trial, you agree?
Yes, Your Honor.
Okay, that's fine. And when would you like to go to trial?
Later in the year, Your Honor.
Okay, I'm going to set you guys this summer. I'll set you in June. Have a great day. That's when I'm setting trials. We'll send you trial order in June 2019. Thank you so much. Have a great day, everyone. Wells Fargo versus Bryant. Council Reddick, good morning. All right, what is the status of this case?
It was a loss mitigation hold, just came off. They filed my colleagues filed a summary judgment yesterday.
Oh, great.
They'll be sending it for summary judgment.
Just indicate in the order it should be set for summary judgment within 45 days. Just put that in the case management order.
Thank you.
Thank you so much. Bank of America versus O'Neill. Bank of America versus O'Neill, 2018-13277. Anyone here on that one? No show? Bank of New York versus Pemberton, 2018-4215. Councilor Reddy, good morning.
Secretary Scott.
Yeah, what's the status of this one?
Judge, fortunately, we have a pending trial modification. I believe the first payment has been made.
Okay,
So,
that's fine. I'll do 90 days CMC.
all right.
Thank you. Have a great day.
You too, Judge.
Okay, HSBC Bank versus Fernandez.
Good morning, Your Honor.
Good morning.
Keith also for the plaintiff HSBC. Your Honor,
Yes.
opposing counsel is Gordon Black. He's actually with his grandmother who's turning 90.
Okay,
He did give me his cell phone number if you'd like.
he can be with his grandmother. What's the status of the case?
The case is procedurally at issue. We're creating an affidavit of plaintiff to do a summary judgment. If you'd like to set it for trial in June.
That's, well, I'm not sending out foreclosures in June. Foreclosures will be set out 45 days for trial.
Okay.
Okay, we'll send you trial order, 45 days.
Your Honor, do you need the?
Yeah, just fill that order out and hand it to the bailiff.
Yes, thank you.
Thank you so much. HSBC Bank versus Slidell.
Yes, Your Honor.
Council Reddy, good morning. All right, and what is the status of this case?
Your Honor, we've had this case on hold for a streamlined modification approval that hasn't been approved yet. Bar was filed a pro se answer. We're going to need to enter defaults against two parties, an unknown tenant, and I think one of the parties from the United States federal government.
Okay,
But
set the motions for default for hearing in UMC?
We haven't filed them yet because of the hold.
Okay, that's fine. Now, well, we can't do both, so you need to proceed then. Otherwise, I'm going to set you guys, they did file pro se answer, I'm going to set you for trial. I'll set you for trial within 45 days. That'll move the case forward.
Yes, Your Honor.
Okay, thank you. Loan Depot Commerce versus Ramirez. Anyone here on 2018-14524? No show? JP Morgan Chase versus Jackson. Counsel ready on that one? JP Morgan Chase Jackson, counsel ready? All right, good morning.
Good morning, Your Honor.
Good morning, guys. All right, what is the status of this case?
We have a motion to strike defensive.
Okay.
I know you'd like to set that, not special set, on motion calendar.
Yes, please.
And I think we called their office yesterday. They were attempting to get it set on next motion calendar. We'll get it on.
That's fine. Go ahead and set that for UMC within 30 days.
Okay.
Thank you so much.
Thank you.
All right, Bank of New York Mellon versus Markowski. Good morning. All right. Yes.
Laura
And
Mullen for the plaintiff.
what's the status of this case?
Now, this case is on a hold for loss mitigation. We're waiting for confirmation for the permanent modification.
Oh, good.
Trial payments have been made, so if we could just reset.
Perfect. CMC 90 days. Keep making your payments, 90 days.
Your Honor, would you like me to draft it?
Yeah, just put that in that case management order. Thank you so much.
Your Honor, I'm
Yes.
already paying through the end of May.
Oh, great. That's wonderful. Congratulations. We want you to try to help you save your house. So we're going to go ahead and make sure you make your payments and the case will be dismissed.
Okay.
Thank you. Do you have any questions?
No,
Okay.
thank you.
Good luck to you, sir.
Thank you, Your Honor.
All right, Nation Star versus Acosta.
That's me as well,
Okay.
Your Honor. Henley was here, both counsel was here. This case is also on hold due to a repayment plan.
Okay.
So we'd ask for it to be reset.
I'll do 90 day CMC.
Thank you, Your Honor.
Thank you so much. MidFirst Bank versus Mason. MidFirst, anyone here on MidFirst Mason? All right, counsel ready? All right, good morning.
Good morning.
All right, what is the status of this case?
Actually, on this one, we are finishing up service. There is a notice of action that was just filed. The publication dates are 2/26 and 3/29.
Okay,
So once that's done, we'll drop the unknown tenants that were served. The HOA just filed an answer. We responded to it, so.
okay, 90 day CMC on this one then.
Thank you.
All right, thank you guys. Have a great day. JP Morgan Chase versus Perlman.
Yes, Your Honor.
Counsel ready? Come on up on that one. All right, good morning. This is JP Morgan Chase versus Perlman. And what's the status of this case?
Morning, Your Honor. We're waiting on our client to send us an affidavit that we edited just so that we can prepare to submit our motion.
Okay, go ahead and set that for summary judgment, let's say within 45 days then. All right, just put that in the order. Thank you guys. Have a great day.
Thanks, Judge.
All right, Deutsche Bank versus Schwartz.
Yes, Your Honor. This one. Very nice to have the link, Your Honor.
Okay, that's fine then. All right, this is Deutsche Bank Schwartz. What's the status of this case, guys?
We have one of the mortgagors who filed a motion for extension of time back on December 3rd,
That's granted.
and that's it.
That's it. Okay, motion for extension time is granted to do what? File an answer? You have 10 days to file an answer from today's date.
It's out negotiations as well.
That's fine, great.
So just wanted to find
Keep trying to get it settled, but you need to file an answer within 10 days.
10 days.
10 days from today's date. All right, thank you so much. Have a great, and I'm going to do 90 day CMC.
Yes, Your Honor.
All right, thank you guys. Number 4, I'm going to recall Bank of New York, Bank of America versus O'Neill, number 3. That was a no-show. Bank of New York versus O'Neill. Anyone here on that one? Counsel ready? Come on up. Come on up. Yeah, absolutely. Just watch your step. And you are Miss O'Neill?
Yes, well, it's Riddle, but yes,
Okay,
that was
that's
my
fine.
maiden name.
Is anybody here for the other side? Well, guess what? Case dismissed. Have a great day.
I'm sorry, what case was that?
Bank of New York versus Bank of America versus O'Neill.
So with,
That means the case is dismissed.
okay.
Good luck. Congratulations.
What do I?
You don't need to do anything. The case is dismissed.
Okay.
Bank of America versus Getty.
Good morning,
Good
again.
morning. All right, what's the status of this case?
Your Honor, our client has this on hold, but there was a motion to dismiss file because nothing is yet.
Yeah, we need to set that for UMC within the next 25 days. All right, and then we'll go ahead and set the motion dismiss. Okay, thank you guys. All right, just put that in the order. Have a great day, guys. Wells Fargo versus Bell Cole.
Yes, Your Honor.
All right, good morning, guys.
Good morning.
All right, what's the status of this case, guys?
I was just informed that the defendant retained counsel, and I've been told we filed a motion to dismiss. I haven't seen it.
Not a problem. If it's been filed, set it for hearing.
Yep, that's all we need.
Okay, go ahead and set it for hearing within 30 days then.
30 days.
Yep, at UMC. Perfect.
Thank you, Your Honor.
Thank you, guys. Have a great day.
You too.
Thank you.
Bank of America versus Lassiter. Yes.
No, Your Honor, we were instructed by the bailiff to address the, well, it's one of the ones we're just saying.
Just wait. I have to do one at a time. Hold on a second. Bank of America versus Lassiter. Yes. Good morning. What's the status of this?
This case is at issue.
Okay,
but
great.
there's a title claim
Oh,
that's
okay.
pending. So plaintiff is requesting another CMC.
Okay. Where's the title case? Is that another division?
So I recently filed my stipulation of substitution to counsel,
Okay.
substitute in for Maxine Cheeseman, who was
Okay.
elected. So I recently came on, but I know my client's working on reinstating or getting Elmer funds.
Oh, okay, great.
So we would ask for a reset of the CMC.
Yeah, that's fine. I'll do 90 days
90
CMC.
days.
Thank you, guys. Have a great day.
And then procedurally, if I can just get
Yeah.
another substitution.
I'll just get that to the bailiff. I'll be happy to sign it. Thank you, guys. Have a great day. So what case are you hearing, counsel?
Wilmington Trust versus Singh, Your Honor.
Yes.
We have an agreed order we submitted, but council wanted to address.
Sure. What's the issue on the agreed order?
We have an agreed order and it addresses depositions. We previously had this case, that was set in this case.
Okay.
The defendant filed bankruptcy and it was stayed, now we're opening again.
Okay, great.
And we already did the subpoena to Stephen for his client. I
Okay.
just wanted the order to reflect that if it's set within 30 days of today's date, he'll still have to comply with the subpoena to Stephen.
I think that's fair. Is there any objection?
Yes, Judge, we would object because the rules don't allow that to happen. We get at least 30 days. It's considered.
They do. Yeah, they do get 30 days under the rules. He's
And-
correct.
And based on, we just got the dates from Judge Curley's judicial assistant.
Okay.
Third for the motion for summary judgment, so we don't anticipate it being a problem.
Okay.
We do have objections.
That's fine. Then do you guys want to change the order then?
It doesn't reflect it as yet, Your Honor. The only reason I asked for it is because we've had issues with setting deposition of the defendant
No.
in this case, and I didn't want to be stuck in the 3 week.
But I think council's correct on the 30-day rule. So we have to be consistent with the 30-day rule. So why don't you, I'm gonna hand you guys back the order. Just go ahead and make the modifications.
It's not on there yet.
It's good. Okay.
There's nothing to-
Okay, you're good then.
Thank you.
Okay, no problem then.
Ashley Morrison on behalf of the plaintiff.
Yep, that's the order. Perfect. Cantons versus Saavedra. Anyone here in 2018-15549? No show? Partners for Payment versus Hara Prasad. 2018-7102. No show? Nation Star versus the United States of America. 2018-11579. Ready? All right, good morning, council. What's the status of this case?
Opposing counsel asked to appear by phone.
Sure, what's the phone number?
It is 954
Uh-huh,
558
558.
4090.
Okay, let me give him a call.
Larry Franco speaking.
Oh, good morning. This is Judge Sasser. I'm calling you on Nation Star versus United States. What's the status of the case, counsel?
I got an email, you have to please.
Whoever's the claims counsel.
We recently filed a motion for clerk's default and it's still pending review with the clerk. But once those are determined, we'll do that.
That's fine then. Okay, so on that one, we'll do a 90-day CMC since you're going to get your clerk's default then. All right, thank you guys. Have a great day, everyone.
Sounds good, thank you.
Thank you. All right, Reverse Mortgage Solutions versus Estate of German.
Morning, Your Honor.
Good morning.
Hillary Mullen for the plaintiff.
Yeah, what's the status of this case?
This case is not an issue. The amended complaint was just filed in the end of November. Service is being completed on the newly added defendants. The answer period will expire March 4th.
Okay, that's fine. 90-day CMC on that one.
Thank you, Your Honor.
All right, let me go ahead and do Dover Condo versus Gross. All right, counsel ready? All right, good morning. And what is the status of this case?
We're still trying to serve the defendant. He's in New York.
Do you need more time?
Yeah.
How much more time do you need?
who knows, we tried to serve them by registered mail, we haven't received the package.
Okay.
I would say to err on the side of caution.
120 days?
Yeah.
Just put that in the order and hand that to the elephant.
Great.
Okay, thank you so much. Wellington Preserve versus Wellington Preserve. Council ready on that one? All right, good morning.
Morning, Your Honor.
Good morning, and
Go back on behalf of the HOA, Wellington Consumer Management Association. Your Honor, we also are still effectuating service on the tenants. We originally put the file on hold, looks like it's being solved. Now it's not.
do you need more time or you
Yes,
okay?
I filed a motion 2 days ago.
You're gonna grant, no, that's fine, I'll grant it. How much more time do you need?
90 days, Your Honor.
90 days it is, just hand the orders to the bailiff. Thank you so much. Wells Fargo versus Delit. Yeah, good morning. What's the status of that case?
Your Honor, Mr. Della has until March 17th to respond.
Wonderful then. All right, I'll do 90 days CMC. Okay, JP Morgan Johnson. Council ready? All right, good morning. And what's the status of this case?
We are not at issue. They, defendant cross-noticed a motion for extension of time.
Okay, are you the defendant, Ms. Johnson?
Yes.
Okay, I'm gonna grant your motion. How much more time do you need?
45 days.
45 days to file the answer? That's a long time then, because we normally, under the rules, we only give 30 days and you've already had time. So I'm gonna give you 20 days to file the answer. Okay, I'm gonna grant your motion, 20 days to file the answer then. All right, and then we'll do 90 days CMC. Thank you, guys. All right, Mary Home Mortgage versus Hilaire.
Yes, Your Honor. Morning again.
All right, and what's the status of this case?
Service is not yet complete. This case was just filed November 16th. We have until March 16th to complete service under the rules. We've got 2 defendants have answered. We're still waiting for service returns from our processor.
Okay, I'll give you 90 days CMC on that one.
Thank you.
All right, Federal National Mortgage versus Burge.
I'm here on that one as well.
Okay. Council ready?
This case is at issue. Trial was just continued because there was a servicing transfer from lender to lender.
So when do you guys do want another trial date?
I think as long as it's about 60 days or more out.
Is that okay? 60 days trial date?
We got for 90 days out at least. Client has recently received a trial loan modification.
Oh, good.
from
Okay,
the,
great.
the
Okay,
new servicer.
so I'll do 90-day trial. Wonderful. Thank you, guys. Have a great day.
Thank you, Your Honor.
Bank of New York versus the State of Armstrong.
Yes, Your Honor. Morgan Heights, on behalf of the plaintiff, we have recently published on 2 unknown errors. We're going to need to get a gavel in the case. So,
Okay, that's fine. So we'll do 90 days. CMC. You're going to need more time.
okay, fair enough.
The HOA? Perfect. So we're moving it forward.
Thank
You guys all right?
90 days CMC.
90 days CMC.
Your Honor, can you return to slide L for a moment?
Hold on, let me just slide out. All right, yes.
You had said the trial would be set within 45 days.
Yeah.
I just want to make sure that we're on the same page. There are, even though the borrower has filed a pro se response, there are 2 parties that have not been defaulted yet and have not filed a motion.
Oh, okay. I'll do 90-day trial then.
Thank you.
Okay, so I'll just change it to 90 days trial.
Great.
Okay, thank you, no problem. Let me go ahead and do Bayview Loan Servicing versus, we just did, okay, actually, this is Bayview versus Marie Leo. Council ready on that one?
Yes.
All right, good morning.
Calling the court for the plaintiff.
Yes.
I believe defense counsel Frank Tyson.
Council's here? Anyone here? No? Okay, what's the status of the case?
Your Honor, the case is not at issue. We're pending the expiration of time for the unknown spouse to file an answer, and we also need to see the gal. We can get a 90 days.
90 days, yeah, that should be enough time.
And Your Honor,
We
we
did
were
right.
also set this morning to strike the defendant's affirmative defenses. I don't know.
No, I can do that. That's fine. You ready?
I didn't get that.
Oh.
Can we step out?
Sure. Why don't you step out and see if you can work it out then? Otherwise, come on back and I'll be happy to recall you guys. All right, let me do MidFirst Bank versus Sullivan. Council ready? Good morning.
Good morning, Your Honor. Liz Morgan on behalf of the plaintiff.
And what's the status of this case?
Actually, the defendant just completed the modification. It's being finalized, so we're going to be dismissing soon.
Wonderful. That sounds great then. Okay, let's go ahead and do Bank of New York Mellon versus Colt.
Morning again, Your Honor.
Good morning. What's the status of this case?
Your Honor, we entered into an agreed order and a motion for extension of time with the defendant. I do have a proposed order.
Yeah,
for
just
your-
hand that to the bailiff and I'll be happy to sign it then.
Thank you, Your Honor.
Thank you so much. All right, let's go ahead and do 21st Mortgage versus Lemansky.
Morning, Your Honor.
All right.
On this, we set up the first one for the plaintiff. And on this, we have motion, we have 2 trustees.
Okay.
And we can't find them, they're both deceased.
Do you need more time?
I think we, did a motion. Do you have to get it on? Yes, Rachel Fahey, on behalf of
I'll be checking. Okay. So do you need more time, Ms. Grossman?
Yeah, I think we need another CMC.
Okay, do you need more time for service or anything on that?
Yeah, we can't find them.
Okay, yeah, so let me do this. I'll do 90-day CMC and then I will extend the time for service as well. So I'll give you 60 additional days for service. And hopefully there'll be enough time for you to find the other individuals for service then.
Your Honor, may the county be excused from the CMC?
Yes, county doesn't need to appear. All right, thank you so much.
And Judge, I have one other one.
Sure, Ms. Grossman.
Penny Mac versus Ralph Marsh.
Yes, that's number 42.
Mr. Cortez is present on
Sure,
that.
yeah, what's the status?
We have a motion for leave to amend the complaint. It's noticed for February 26th.
Oh, well, I'll just grant it today unless there's any objection.
No objection.
Okay, I'll grant that, that's fine. Just hand the orders to bailiff. And we'll do a 90-day CMC on that too.
And lastly, Judge, I had an agreed order in Judge Hurley.
Just hand us the bailiff.
Okay, thank you.
Thank you, have a great
Thank you,
day.
Judge.
All right, Astoria Bank versus Calvary SPV. Counselor, ready on that one? All right, good morning. All right, yes, and what's the status of this case?
Yeah, I'm Tim Quinones for the defendant.
Anyone here for the plaintiff? Astoria Bank versus Calvary? Case dismissed. Have a great day.
All right, thank you, Your Honor.
All right, JP Morgan versus Wengroff.
Your Honor, do I need to prepare an order for that?
We'll take care of that.
Okay.
You'll get that order today.
Thank you.
Thank you. JP Morgan versus Wengroff?
Morning.
Morning. All right, what's the status of this case?
Your Honor, the defendant filed a pro se answer. They said they're evaluating their options and we are moving to prepare for a summary.
Do you represent the defendant?
No, I am actually,
Oh, you're the
my mother and I
Oh,
were.
you're the- okay. That's fine then. Okay, no problem then. All right, so that, at that point in time, you file the answer then, so I can set you guys for trial?
We're preparing summary judgment.
Oh, they're gonna file summary judgment. You don't want to check the bank to see if you can work something out
I
on this
already been
one?
in contact with JP Morgan Chase with Phelan Allen's file.
Okay, oh, that would be great then if you guys can work it out.
I
Otherwise,
haven't, I've already contacted Phelan Allen and spoken to two different individuals from the firm.
okay, oh, that's
I've
fine.
been working on it.
Okay, great. We want to try to help you save your house and set the summary judgment within 45 days then. Thank you guys. Have a great day.
Thank you.
Thank you guys. All right, Carrington Mortgage versus Duclair. All right, good morning. And what's the status of this one?
Not an issue. We need to file motions for default. It's currently on hold for a short sale review.
Okay, that's fine then. Let me do 90-day CMC.
Okay, and Judge, I have one other one that wasn't on the list.
Sure, which one?
Well,
I just need the case number.
181392.
1392. And what's the status of that one?
That is at issue.
Okay, all right, that's fine then. So we'll do 90 days. Well, actually, that one's at issue. Can I set you for trial?
Okay.
How much time for the trial?
I think it's a 15-minute.
Okay, so go ahead and set it for trial within 45 days. All right, we'll set it for trial UMC 45 days.
Okay.
Thank you so much.
Thank you.
Wilmington Savings, Benzali. Counselor, reading that one? All right, good morning. And what's the status of this one?
Actually, we recently learned that the main defendant passed away, and we're going to be moving for a gal to be
Gal,
appointed.
okay.
The daughters live in Spain,
Okay,
so
that's fine. We'll do 90-day CMC on that one. You'll need more time.
terrific.
Okay, let me do Freedom Mortgage Everett. Anyone here, Freedom Everett? No show? Okay. Deutsche Bank Toscano. Counselor?
The defendant,
Yes.
Michael Toscano.
All right, good morning, guys. And what's the status of this case?
Your Honor, and I apologize, you had directed us to reset the summary judgment for us to file a motion to vacate that prior judgment.
Correct.
So working on that, haven't quite.
This one's a bit of a mess. So how much more time do you need?
We could, I don't know, 45 days.
Okay, is that okay? 45 days to reset?
It's not gonna take that long, but.
I'll give you enough time then. So what I'll do is summary judgment to be set within 45 days then.
Okay, so
Just put that in the order. Perfect. Thank you, guys.
Thank you.
Thanks.
All right, US Bank Trust Rouse. US Bank Trust Rouse. All right, Council ready? All right, and what's the status of this one?
Christopher Peck on behalf of the plaintiff, there's currently one motion pending in front of the court for motion to substitute plaintiff's counsel.
Okay, which I'll grant, just hand the orders to bail.
Super. Also, we have just filed all the affidavits. We're filing for a motion for summary judgment.
Just indicate the summary judgment shall be set within 45 days.
Thank you, Your Honor.
Perfect, thank you so much. Bank of New York Mellon versus Mills.
Yes, Your Honor. This case is not quite an issue. We did just complete service after filing a case in October. We're pending some defaults and drops. We haven't filed motions yet, but it shouldn't take too long.
Okay, that's fine then. Go ahead and indicate shall be set for summary judgment, let's say within 60 days. Hopefully that'll be enough time.
Yes, Your Honor.
All right, thank you so much. US Bank versus Avalos. All right. All right, good morning. And what's the status of this case?
Your Honor, the defendant is being reviewed for loss mitigation, so the
Okay.
file is on hold, and the complaint also needs to be amended.
Go, is there any objection?
No, the borrower was pro se.
Okay, that's fine then. I'll go ahead and bring over to this motion for leave to amend. Let's put that in the order today. And what I will do is I will go ahead and do a 60-day CMC.
And is there a deadline to amend?
Deadline to amend within 10 days.
Okay, thank you.
Thank you. AmeriHome Mortgage versus Maine.
Yes, Your Honor, again, for the plaintiff. This one, we're not quite done with service, and we're awaiting the return of one more service return from our process server. We've served everyone else. The time for service already technically expired.
Okay, do you want more time?
I asked for 45 days, should be plenty.
Let me give you 45 more days for service then, and that way they'll give you more time then.
Thank you.
Perfect, thank you so much. All right, let me start again with the UMCs. Cohen versus Liberty Mutual Fire. Counsel ready in that one?
I'm on that one, Judge.
All right, good morning. Are you expecting the other side?
Yes, I was, and I believe that he didn't have it on his calendar, so he's asked for permission to appear by phone.
Sure, yeah, that's fine. What's his phone number?
It's 1561 855 2120, Your Honor. His name is Javier Delgado.
Let me give him a call, that's fine. Do you want to go outside and try to call him?
I just spoken with him actually.
Oh, wait, yeah. Hi, this is Judge Sasser. I'm calling on Cohen versus Liberty Mutual. Is the attorney ready for the hearing this morning?
I'm sorry, which attorney?
Who's the attorney covering?
Javier Delgado.
Mr. Delgado.
Thank you. And your name again?
Judge Sasser.
I can barely hear you.
Judge Sasser.
Judge
Sasser, yes, ma'am.
Thank you. One moment.
Thank you.
Thank you.
Thank you for calling Merlin Law Group, the policyholder's advocate. To learn more about us, visit our website, www.merlinlawgroup.com. We'll be back momentarily to take your call.
Sure, of course.
Good morning, Your Honor.
Oh, good morning, Mr. Delgado. This is Judge Sasser. I'm calling you on the hearing on defendant's motion to dismiss count 2 of the complaint, and I had read everything ahead of time. This is regarding the deck action, is that correct?
Your Honor.
All right, you may proceed with additional argument on the motion to dismiss. Yeah, thank you. Why am I looking at all the policy stuff on the motion to dismiss? Is this outside of Four Corners? I don't need this. I can't look at this stuff.
Okay.
We know the rules on the motion to dismiss, right?
Yes, Your Honor.
Please don't hand that to me.
Okay. Thank you.
So,
this is Holly Galinsky on behalf of Liberty Mutual, and we're here because we filed a motion to dismiss based on count 2 of the declaratory relief. And the nature of this claim is that they brought a breach of contract action also. And there's
but they're pled in the alternative, right?
They are put in the alternative, Your Honor, but they're arguing that there's a dispute as to coverage, but there's not. Your Honor, we applied coverage, afforded coverage for everything but repair to the plumbing system that leaked. And Your Honor, everything else has been afforded. They're arguing over the scope and pricing. There's a huge.
But what if they fail to plead in the deck action from the prima facie case?
They filed an opposition to our motion to dismiss, which is in conflict with their complaint. Their complaint is alleging that it's ambiguous as to the statement that we will not pay for the plumbing repairs. And in their opposition, which Your Honor has a copy of, they are pleading that there is an issue with respect to subsection 6. They're claiming that there's a hurricane loss and that there's some.
Okay, all right, let me check with Mr. Delgado. Are you claiming a hurricane loss issue, or what's the basis of count 2?
Your Honor, this is a water damage claim, essentially, and the insurance carrier essentially paid for a part of the claim, but denied the other part based on its interpretation of the policy language. Now, in the affirmative defenses, affirmative defense number 1, the defendant argued that they are claiming the entire insurance policy as an affirmative defense.
Okay.
And in defense number 8, they're specifically stating that they do not insure for items caused by wear and tear, marring, deterioration, and so forth.
Okay.
And so, as we know in Higgins versus State Farm, the Florida Supreme Court in 2004 indicated that you can have a declaratory judgment.
Sure, of course. Yeah, Higgins said that. But my only question is, what's your legal theory? Is it the hurricane issue or is it the coverage issue in count two? Because defense counsel is saying your allegations of the complaint are inconsistent with the position you're taking in response to the motion to dismiss.
No, essentially, the reason for our complaint, with regard to the deck action is that the carrier essentially is relying on, a policy exclusion, wear and tear, pre-existing conditions and so forth, to only pay a part of the claim. What we're seeking is a court to determine the policy provisions that they're relying on.
Got it. All right. Anything else in the motion to dismiss?
Yes, absolutely, Your Honor. Specifically in the complaint, they're specifying the language about the plumbing repairs.
Yes.
And the dispute is about $20-something thousand. Their estimate does not even include the plumbing repairs. So they're not really asking for.
But this is a motion to dismiss. Remember, I have to take all the allegations and complaint is true.
But the allegations in their opposing motion are completely contrary, and they're saying that they're trying to interpret a different provision of the policy.
Okay.
The policy is absolutely clear as to what's
I can't
covered.
make that legal determination on whether an insurance policy is clear on a motion to dismiss. That sounds like you need to bring it on the motion for summary judgment.
Okay, Your Honor, just with respect to Higgins, also, I would argue that that's irrelevant here because this is a first-party breach of contract action. And
Okay.
as you know, was.
It's a third party, I understand.
Duty to defend, so I would ask that Your Honor grant our motion to dismiss as is within your Honor's authority.
Okay, I'm going to deny the motion to dismiss. How much time do you need to answer the complaint?
10 days.
Okay, 10 days to answer. Thank you, guys. Have a great day.
Thank you, Your Honor.
Let me do Wells Fargo versus Sasser, please. Counsel ready on that one?
Yes, Your Honor.
All right, good morning. And what is the status of this case? Oh, actually, it says UMC here. All right, so,
A motion to transfer Your Honor, Wayne Pinnock on behalf of Anastasia Sustar as the
is
guardian.
there any objection to transfer?
Actually, Roseanne Morgan on behalf of the plaintiff, we do have an objection to transfer. They're referring to a 2008 administrative order.
Yeah.
This case is the one that's from 2017. Judgment is entered with an extended sale date.
But is there a related case? That's my only question.
Yes, there are two related cases.
Yeah, so which division's got the lowest case number?
Both of the other cases are in Division IH, just share.
That's fine. We'll be happy to send them to him. Okay.
I have a blank over
That's
here.
fine, just hand the words to bailiff then.
Okay,
Thank you so much. Have a great day.
Thank you, Your Honor.
All right, let me go ahead and please do Freedom Mortgage versus Johnson. Agreed order? If you have an agreed order, you can just hand that to the bailiff. All right, that's fine then. Muni Commerce versus Navador. Counsel ready? All right, good morning. Thank you for your patience. And we have a court order? No? Okay, all right. Good morning. All right, so Muni Commerce versus Navador. This is plaintiff's motion for court determination on whether the subpoena is required for Navador's agents. You may proceed when you're ready, counsel.
Yes, Your Honor, briefly. Plaintiff's ready to take some depositions, and we've identified 5 people. Obviously, the first one is the defendant, so that's not a problem.
Okay.
But the next one is, I've got this off their website.
Yeah.
That's to their title, Sales Director, Vice President, Sales Manager, Operations Supervisor. I don't believe they need to be subpoenaed.
Are they managing agents? Are they managing agents? The rule requires you have to subpoena them unless they're a managing agent.
Correct.
Officially, Judge, 3 of them live overseas. I hate to
Okay, go ahead.
Your Honor, it says officer, I have a case that says.
Oh, yeah, officer, director.
Officer, director, or managing agent.
Okay, all right.
Sales director.
Okay. Sales director is not an officer of a company.
It's sort of a managing agent according to Black's Law Dictionary.
Sales director, anybody could be a sales director of any company. A sales director is not an officer of a corporation.
Vice president.
Vice president is
She
an
lives in
officer.
Morocco, yes.
Okay, yeah, that's fine. You can do it as long as you comply with the Hague Convention. Well, actually, that's fine. Okay.
Operations supervisor.
Operations supervisor is probably not high enough in a company, I would assume. So that one's denied as well. You're gonna need to subpoena that person.
Okay.
Okay, all right, thank you guys. Have a great day. Thank you. All right, let's do Mew versus Boca Group. More motion for mediation? Mew versus Boca Group? Anyone here on that one? That's yours?
I just have a question.
Oh, yeah, come on up.
Agreed order?
Yeah.
Would you grant an agreed, can we submit an agreed order on a motion for continuance?
Absolutely, I can always do that. You never even need to come here. I'm the only judge that does that. Remember, I'm the nice judge, so you can just email that. So you guys don't even need to waste your time. Don't bill your clients, just email me. Have a great day.
Thanks, Rita, you think?
All right, let's do New Penn Financial versus Jacobs. Counsel ready on that one? That's the foreclosure trial? All right, good morning. Do you have a witness or is this the documents?
Just the document.
Okay, that's fine. Everything looks to be in order. And when would you like a sale date?
45 days.
Just put that on the first page and just hand us the bill. Thank you so much. Have a great day. Let's do courts at Boynton Place versus Nelcador. Okay. This is a motion to quash.
Morning, Your Honor.
Good morning.
So there's been some development since I filed the motion. I have two different orders. There was a stipulation of settlement that I have with the defendant yesterday.
Okay.
So what I want to do, just to clean up the file, because it's a settlement and he still may not make the payments.
Okay.
I want to have an order of quashing it, so submitting to the jurisdiction to the stipulation, and then vacating the final judgment, vacating the default, giving us leave to amend in the event that we have to if he breaches the stipulation. Then I have a separate order dismissing the case with jurisdiction to enforce the terms.
That's fine. So we'll do both orders then. That's
Exactly.
perfectly fine. Just hand both orders
Thank you,
together.
Your Honor.
Perfect. Thank you so much. Let me go ahead and do Ramirez Global versus Vishnu All. Motion for mediation. Council ready on that one? Okay, that's fine. I'm just waiting for everybody to come up. All right, good morning, guys. This is Ramirez Global versus Vishnu et al. Could council please state their appearances for the record?
Yes, Your Honor. Robert Glass on behalf of plaintiff Ramirez Global.
Larissa Rodriguez, we have with them Chapman's and Big Capital.
Good morning. It's nice to see both of you. We're here on plaintiff's motion to set date certain for mediation and deposition, and I read both motions. Mr. Glass, you may proceed when you're ready.
Your Honor, I mean, my client is ready to go to trial. The trial's been set since November, and the only thing that's standing in our way right now is the fact that we have not gotten a date where we can conduct a mediation, and we haven't gotten a date to conduct a deposition of the defendant.
I know. Any objection? They're entitled to that.
Your Honor, there is a second motion.
Okay, that's fine. I'm happy to do both. But what's the response to this? But what's the response to this motion?
It's a scheduling conflict, Your Honor. We just need a little more time to schedule the date because the defendant lives in California. So what we had
When do
discussed
you think you can do that?
March.
March?
And that's outside of the current trial.
That's my problem, because I special set everything in here, like I said, to make your life as easy as possible. I can move it if you want to, but you have to mediate and you have to allow the deposition.
100%, Your Honor, and there's no objection to doing that.
But let me see if Mr. Glass's client would be prejudiced. When would you like the trial?
I mean, my client would like to go forward with the current setting. I mean, I'll be practical, like I understand scheduling conflicts happen. But
do you want to move it to April maybe, and then we could do the mediation?
The only thing is if we move it, I mean, my client's going to want some kind of date certain by which both of these.
You get it. No, absolutely. Both. You're going to entitle to both. You're going to get a date certain. I want by 5 o'clock today, the date for the mediation, and by 5 o'clock today for the deposition date. And if you guys check your calendars, Michelle will give you a date certain for the trial in April, whatever works best for you guys. If that works, that way you'll get the mediation done, you will get the deposition done, and you will have a date certain for the trial. So hopefully, does that work for everybody?
I mean, my client won't be thrilled, but it works.
No, I'm happy.
I understand the practice.
Yeah, I'm happy to do that for everybody if that works.
We can make that work.
Is that okay? I just want to make sure you have to give them mediation and you have to give.
Doable. February wasn't. That was the issue.
Okay, but please give them a date today.
And I mean, her client's been ordered by Judge Tudor and Broward to appear for a deposition in Miami by March 13th. So.
Can we do the deposition at the same time?
No, Your Honor, they haven't scheduled the deposition. In that case, they've been ordered, but they haven't noticed it yet because they're not.
But if Judge Tudor already ordered it by the 13th, why can't you do the deposition in this case at the same time?
Your Honor, my client hasn't given me the availability for that time.
Okay, but you're going to by 5 o'clock today though. So, and I think that might actually work if they're going to already be here.
If they are going to be here, Your Honor, yes. If that is going forward, we'll make it work.
Well, I think I will make it work. So why don't we indicate that deposition is March 13th okay with you guys?
That deadline will work for us.
Okay, so I'm going to order the deposition by March 13th. Because like I said, I'm basically granting you a continuance because of your client schedule. So March 13th deposition for certain in Miami, hopefully. That'll save everybody some time and expense since your client's going to be here anyway. And then let's go ahead and do the mediation. Can you do the mediation in conjunction with the client's visit to Miami?
We can do that, Your Honor.
That would save.
I have one request. In the event that the Broward case, for whatever reason, on March 13th does not happen for whatever reason. I already know for a fact that the following week is available.
Okay.
So I would just request, I don't want to.
So by March 20th? Okay.
Correct. If we put the March 20th date in there,
Then you'll have a date certain. So it's mediation by March 20th for certain and deposition by March 20th. And I'll set you guys for trial maybe the first week of April. So that way there's no extended prejudice in any way. And that way you'll have a date certain for trial if that works.
I will just say, Your Honor, I'm leaving town on April 4th, so if it's earlier in that week, that would be fine.
Whenever works, I'm happy to work around your schedule, or we can even do it when you come back, whatever works best for you.
I would prefer when he comes back, Your Honor.
I see a theme here, but I think he gets to choose the date since we're trying to accommodate your client's schedule. So Mr. Glass, whatever date you want, just email Michelle, we'll be happy to take care of it.
Okay. All right.
Thank you guys, have a great day. All right, let me go ahead and do please. Kimmel versus Wellington Regional. Council ready?
They can take our April trial. They can-
Okay, I know. You guys are giving it away. Okay, so what is the stats? We have a court order on Kimmel? No, okay, all right, what's going on in Kimmel, guys?
We actually, the plaintiff was on the phone.
Oh, yeah, I just need a phone number. Oh, here it is, the 305 number?
Right.
Perfect, let me give him a call. That's 506, right? 506. Mark, here's another order.
Good morning, this is Josh Wendell.
Oh, good morning. This is Judge Sasser. I'm calling on Kimmel versus Wellington. And defense counsel are here in the courtroom. We have a couple motions. We have a motion to continue and a motion for leave to file additional interrogatories. Are you ready to proceed?
Yes, Your Honor.
Okay, let's do the motion for continuance first, which I read, and you may proceed when you're ready, counsel.
Sure, thank you, Your Honor. Brad Kimber for Emergency Specialist at Wellington.
I know, and I remember you guys came in before. I said you guys in April. You guys don't think you'll be ready?
No, Your Honor,
Okay.
the case is not going to be ready by April as a result of several special set trials that come immediately before, immediately
Well,
after.
this one's special set too. So this is 2013. Are they older cases or newer cases?
Your Honor, one case is 2009, one case is 2011.
Okay, that's
We
fine.
just bring that to your attention.
Yeah, no, that's fine. So when do you think you guys, and those are definitely going, right?
Definitely.
Okay, that's fine then. So do you guys think you can go in May?
Your Honor, looking at May, one of the issues that we presented to Your Honor at the previous hearing was the fact that Lisa Small's calendar for that special set trial in April, the weeks actually break up in April.
But that's not fair to me and for to do that. So I'm gonna set you guys in May. When would you guys like to go in May?
We're on two dockets, but they're not special.
Okay, that's fine. So just tell me the weeks you'd like to go.
Your Honor, one thing I was going to ask is we actually did confer with plaintiff's counsel via email, and previously after the past hearing, we did agree on a few days that might work in May, June, or July. Would we be able to?
Yeah, just email Michelle. You guys can pick. You guys, in my division, like I said, remember I'm the nice, easy judge. You guys get to pick. You guys get to go to trial when you want to in my division. Just email Michelle.
Okay.
So it's granted, and then we'll discuss the new trial date.
Yep, perfect. Motion continues granted. So just pick the trial date and you guys get to, and you'll be special set for trial in either May, June, or July, whenever you guys want. All right, the next motion is the motion to overrule the objections to the interrogs and the motion for leave to file additional interrogatories.
Your Honor, the motion is predicated on the fact that there was quite a stall in the case, a delay on behalf of the plaintiff. The last interrogatories that were served were the third supplemental interrogatory back in 2017. So it has been a 2-year period now that we have not received any discovery responses from the plaintiff.
Okay.
They're just a supplemental set of interrogatories to get an update on the plaintiff's current status.
Any objection to the supplemental interrogatories?
Your Honor, it's just a mild one, and really the only objection here is that these are, I think, the fourth supplemental set, and I want to say it's the third duplicate set I have of quote updated interrogatories where they've asked the exact same question for the third time.
Okay.
If it's not the third, then it would be the second, sir.
Okay, all right.
And it's just the numerosity of it and going back to the drawing board over and over again.
I know, but this is a 2013 case. I assume your client's still treating, so there might be additional medical issues that they're entitled to know. So I'm going to grant the motion for the supplemental interrogatories then as well. And what about any remaining objections to the interrogatories?
No, Your Honor, the only objection was the fact
Was it
that they were
additional?
over.
Okay, that's fine. So I'm going to grant both motions, the motion to continue and the motion for leave for the additional interrogatories. Email, check your calendars, whatever works with your experts, and I'll be happy to give you guys whatever date you want for trial.
Okay.
Thank you guys. Have a great day, everyone. Thank y'all.
Thank you, Your Honor.
All right, let's do Feinberg versus DeSista. Council ready on that one?
We're getting closer, Your Honor. I finally realized that I've been mispronouncing my phone. You got it right.
Oh, okay.
I'm here.
We're working on it. So, all right, good morning, guys. Could council please state their appearances for the record?
Vinnie Organic for the plaintiff.
Greg Weiser, the defendant.
All right, good morning, guys. And you guys are set for trial, but we have a couple matters. One is a motion limiting regarding the CME, and we also have a motion to strike. Which motion you want to do first?
Your Honor, I think I filed a notice mine first, so can we do mine first?
Yeah, let's do yours
Mine is regarding the CME experts. I know that you've read it.
I did, yeah.
Do you have any questions? I mean, the gist of my argument here is that, they can't talk about things that they're not qualified to talk about. They can't talk about things outside of their report, and they can't criticize Dr.
Yeah, no, we know that, right? We're not going to do that, right?
Well, I'm not going to criticize Dr. Licklau, but they are doctors, they're rehab specialists, the same as Dr. Licklau. They can talk about the reasonableness of the costs.
Okay.
And the case she cites.
But just be careful. No,
says that.
but I understand, but we're not going to criticize Dr. Licklau.
I'm
We
not
just need to be really
gonna
careful
criticize
then. Okay, that's fine then. So yeah, you can talk about the reasonableness of the bills, that comes in every case. But so I'm gonna grant the motion in part, they can talk about the reasonableness of the bills, but there'll be no criticism of plaintiff's expert witness.
What about this business of trying to act as coding experts when they're not?
That's not, they're not acting as coding experts.
How exactly is Liqba gonna testify to this? What is he gonna say?
Well, Liqba is gonna come up with a plan as to the future.
No, but how are you gonna cross him on this, on your CME?
That's not the issue. The issue is my doctors are gonna say that costs that she's looking for her past medical expenses are not reasonable.
Okay, that's fine.
Doctors can certainly say that.
They can say that reasonable, but they can't be coding experts. So I'm gonna go ahead and grant the motion with respect to the coding issues.
What does that mean?
Well, they can't say Medicaid codes it this way or that way unless they have done the background to be able to be qualified to render that expert opinion.
They can talk about the reasonableness.
Yeah, reasonableness of bills always comes in. All right, that's fine then. So now let's do the motion to strike. So the plaintiff's motion is granted.
Anything else?
Anything else in place for me? Okay, let's do defense.
Your Honor, you guys said you read my response.
I did.
Your Honor, let's start with my motion. My motion addresses 3 issues.
Sure.
One has already been agreed to. They had an expert who came in and testified that the golf cart driver was distracted. He admits he was speculating and they agreed to it.
So that one's off the table, right? Okay, that one's easy. Okay, got it.
I think the other easy issue is the right-of-way issue.
Okay.
They have a human factors expert.
Okay.
Has no experience in right-of-way, traffic safety, didn't even look at any statutes. When we asked him who had the right-of-way, he says, well, who's the plaintiff?
Okay.
We asked him why. Well, plaintiffs always got the right-of-way. And then he came up with some other theory that because the golf cart has more of a tendency to injure pedestrians, the pedestrian has the right-of-way. So he comes up with this really nonsense.
But how can I decide that on a motion to strike?
That's what he testified to in his deposition. I'm just moving to strike his deposition testimony, which I believe is what they want to play
Okay,
for.
all right. So what's a basis to strike the deposition
The
testimony?
basis of the testimony is that he has no experience in
So this is a
right-of-way.
Dalbert motion? I mean, it's a Fry motion? What is it? What's the motion?
It's a motion that he said his opinion is not based on anything, and it's just simply contrary to Florida law.
Then make it contemporaneous objection at trial then. So, and I'll hear it at the time of
And
trial.
Your Honor, I would say that he's not wrong. The statute I cited in my response says, notwithstanding the other provision, the pedestrian has the right.
Okay, that's fine then.
So-
Yeah, I mean, it sounds like I just make it a contemporaneous objection at trial and I'll hear it then.
Okay.
All right, and the third basis of the
The
motion?
third basis is, and I think probably the best thing for me to do would be make a contemporaneous
Objection trial.
I'm gonna argue that he bases his diagrams and his location based on hearsay. When the attorney who hired him and the employees told him where the location occurred. Now, they're gonna point out,
I mean,
well,
their expert can rely on hearsay.
there's certain types of hearsay that can, to this point, not where attorneys who hire him tell him this, the
Oh,
accident occurred
I'm
here.
sure that's
Your
not what
Honor,
happened.
but he also
It is what
testified,
happened.
Go ahead.
he also testified that he relied on the claimant's or the driver's deposition who said
Okay.
it was 16 parking spaces.
Yeah, he can rely on the driver's deposition. He can't rely on what the attorney said.
I agree,
Okay.
I agree, but that's not what he said in his video deposition.
Okay, why don't we do this?
So the predicate is not.
He has to lay before that comes in at trial, before that opinion is rendered at trial, he has to lay an appropriate predicate with, hearsay testimony is fine, but he can't use what the attorneys told him, obviously.
Your Honor, yeah, we have the transcript of the deposition, and we'll go over it, but I think it's very clear that, and not only that, yesterday, their expert testified that the accident occurred where Dr. Lloyd said it occurred, which was 16 parking spaces, and
And
we're
that's-
fighting about nothing here. Everybody agrees it occurred 16 parking spaces from the end.
That's
Their
fine.
expert testified to.
Well, that'll be an issue for the jury then. So let me reserve that and just make the contemporaneous objection at time of trial. But again, it has to be a valid basis for the expert testimony then.
Okay.
All right, thank you.
Your Honor,
Anything
one more
else?
thing,
Yeah.
and that is a juror questionnaire.
Yeah.
Opportunity to use one, can we submit an agreed one to you?
Absolutely, yeah. Just email that today. We'll be happy to take care of that for you.
Okay.
24 jurors enough?
I think so.
Okay, that's fine then. Sounds great. All right, thank you guys. Have a great day. Thank you so much.
The questionnaire has to be agreed to.
Yeah, it has to be agreed to. Otherwise, we have one, yeah, it should too. Yeah, no, it needs to be agreed to. Otherwise, we have a standard one we're using that's pretty, the idea is to make it easier for you guys to do jury selection, do all your social media. They will have everything filled out. It's gonna shorten time for voir dire. The attorneys really like the questionnaire. It'll make your life much easier.
Do you actually have a copy of your questionnaire available?
I do. Mark, can you grab the questionnaire form when we get the
That way
chance?
we can see it.
Mark has it. If you just wait a few minutes, Mark will give you a copy. And we're actually using that in every single case and it's working really well. You guys can use it and modify it however you want to.
Sounds great.
All right, thank you so much. Let me go ahead and do, we just did Ramirez versus Vishnu Capital, okay. Actually, this is a different one. Ramirez, Vishnu Capital, did that one, okay. Let me go ahead and do Ditech Financial versus Coleman. Councilor Lee, that one? Yes.
This is just the motion to reopen case.
That's fine, I'm gonna grant it, just hand that to Bill.
Actually, I passed it off.
Oh, no problem.
Thank you.
Okay, all right, let me go ahead and do Wells Fargo versus Sasser. Anyone here on Wells Fargo Sasser? No? Okay. Geico versus Desmond. Councilor Rennie, that one? Okay. And this is a motion for protective order, is that correct?
Yes, Your Honor, the person defendants, provided a phone number.
Sure, yeah, what's the phone number?
914-980-1765.
914-980-1765?
Yes.
Okay, let me give them a call. If, I just have a couple more. If you have any other paperwork, just hand it to the bailiff and I'll be almost finished. On the Rita versus Derek, the unopposed motion for continuance, I'm granting that. I did, yeah. Okay, I'll call him again, because hold on. This is Geico versus Des Masullin. Are you ready on the motion for protective order?
Yes.
Okay, all right, let's proceed. I read the motion.
Yes, Your Honor. I mean, as Your Honor read this motion, plaintiff is asking for a protective order. In this case, there's bodily injuries involved. Plaintiff's not trying to withhold all documents, but because this is sensitive medical information, we're turning over to pro se defendants. We just want an order to be entered, which will simply state that if they want to retain an expert to review it, they may do so. If they want to hire counsel, he may review it, but outside of that, they can't show it to anyone.
Don't show someone's medical records. Do you have any objection to that?
I'm sorry.
You can't show the medical records to other people, only if you're hiring an expert, only if you're using it for this case. Okay.
I had stated in our motion for protective order that I'm willing to sign any type of confidentiality or non-disclosure.
Okay, good. Well, that's fine, but just don't share someone else's medical record with unnecessarily. So just kind of keep everything confidential.
Of course.
All right, thank you. Have a great day. Wonderful. Just hand that to Bill then. All right, Kramer versus Kramer. Councilor Reddy Miller? Here's one. I don't have any other people, and I'll call CMC in just a minute then. All right, let's do Kramer versus Kramer then. All right, good morning, guys. This is
Good morning, Your Honor.
Good morning. We have a couple of different motions. Is that correct?
Yes.
All right, so let's proceed to the court order. All right, which motion do you want to do first?
Your Honor, Kenneth Robinson for defendant, Jeffrey Kramer. But I'd like to address the court's motion in limine pertaining to Edward Kramer's deposition.
Okay.
Edward was a co-plaintiff with his brother Randall. This is a brother versus brother lawsuit.
Okay.
Mr. Edward Kramer passed away several years ago. His deposition was taken by prior counsel for Mr. Jeff Kramer, and they used their first.
Got it. That's fine. Sure.
And Mr. Rackison on the exhibit and witness list identified that deposition that they intended to use, the deposition of Edward Kramer.
Got it.
Unfortunately for us, and not pursuant to the court's pre-trial order, he didn't designate, what portions of it that he wishes to use.
Okay.
So we have an objection, not just because he didn't designate, but because there are portions of Mr. Kramer's testimony. Remember, it's being taken for discovery purposes. He's testifying, I understand, I was told by this person, was told by this person, those type of things.
Okay.
We understand, this motion cannot be heard, unless your honor says otherwise, on a 5, 10, 15 minute.
That's fine. Do you guys want, I'll be happy to special set all the motions. Do you want to do that?
Excuse me?
Do you want to special set all the motions? That's fine.
Well, that was our problem. Ms. Rackison has a very busy schedule.
We have plenty of time.
2 or 3 times we tried to get special setting.
We have time in this division. Just email Michelle. She'll be happy to give you time.
Judge, we agreed that he can specially set it, and we also agreed that if for any reason we couldn't get a special set, we'd reserve some time.
You can always get special sets in this division. That's no problem. Just email Michelle. We'll be happy to do that for you.
We do that. And same thing, or at least part of it, is with respect to the second motion that the defendant filed.
Okay.
And that is with respect to, we've set forth our objections to exhibits. We did meet Mr. Rackison. Came over to our office with 2 boxes of documents. We saw theirs, we produced ours. Unfortunately, the exhibit list that the plaintiff is relying on has, as we've said in our motion, descriptions such as, all documents, all wills, all this.
It needs to be a more detailed exhibit list with what you're using.
And we need to be able to look at what they're producing in terms of documents, Your Honor, and those documents correspond to the exhibit list. And that's all.
That's fine, so
we're
that's
asking.
granted then. So can you give a more detailed exhibit list?
Yes, Your Honor, but I just want to remind the court, last time we came in, we were still doing discovery. We're taking a week from on the 25th. We're getting the, Mr. Jeffrey Kramer is appearing as the trustee and individually. And then we've asked him to bring some documents. We had a motion to compel, but we've kind of resolved that. We're deferring on that motion. He said he's producing some documents. It's probably gonna be my burden at the depot if I think there's something that they didn't bring to at least verify its existence, so we can just get to some specifics. Some of my, I brought all of our exhibits that we had and existed to the meeting. Looked at theirs. A little bit of it is just maybe the difference in strategy. For example, if I just explained, we got an issue about whether Jerome Kramer was competent at the time he did a durable power, the time he was in a VA medical center for several weeks. We're using the entire set of medical records from the VA. Their records consist of 6
But can we
or
just
7
correct, can you
isolated
give more details on the exhibit list?
Well, it's listed as VA records.
But don't say the catch-all. I think he's more worried about more of the catch-alls.
Right, exactly, Judge. And our catch-alls are there because we expected if there's any records on some of those that we didn't get, that they would be there. But if we don't have those, then I'm taking them off the list. I already explained that.
That's fine. Okay, so that'll resolve that issue then. All right, so what else do we have outstanding?
So we'll get that's it. We're gonna defer their motion to compel. We filed a response.
Good.
We are going to call up Chambers and try to get a special set that meets with Mr. Atkinson's schedule. And Your Honor granted it, not you're terrible, but you granted our motion in respect of more detail
On the exhibit list, yep.
And I apologize, we don't have an order on
You
that.
can always email everything.
We'll do that.
And I would like to be able to do that, say, 7 days after the deposition.
Oh, yeah, I think that's fair. You're gonna need it.
I'd like to be able to incorporate and assimilate those
Sure, yeah.
records that we're getting into that.
May I ask the court, since this is our first time in terms of the court setting a jury trial? Your Honor, we've now sent to Chambers that sheet that you fill out.
Yeah, the account to call.
How do we find out?
Everything is always posted on the website and it's updated daily.
Okay.
So you don't even need anything, just click on the internet, everything is updated daily, you know exactly when the trial is and everything is easy and we special set every case.
And would that be in connection with the March 4 calendar coming up?
Absolutely.
Okay.
Thank you guys, we're here to make it as easy as possible for you guys. All right, counsel, which case you got?
Not hear us called, it's you versus Boca Group.
Sure.
Plaintiff is on the phone, it's a plaintiff's motion seeking order referring matter to mediation.
Yeah, I'm gonna grant that then, that's fine then, that's no problem then. I'm gonna grant the motion. Is there an objection to the
Yeah,
mediation?
we're nowhere near an issue, I'd like to, I mean, if you want to call.
Oh, okay,
It's
that's
not,
fine.
we're not set for trial.
Oh,
I don't
okay,
want to
that's fine.
argue it.
No, what's the phone number?
His name's Alan Levine.
Okay.
His number is 954
Okay,
683
683.
3359.
Okay, let me give him a call. Oh, counsel, on telephone, this is Judge Sasser. I'm calling you on the motion to compel mediation. Are you ready?
I am ready. Thanks for letting me appear by phone.
Not a problem. And there's a basis for objection. Counsel saying he's not ready for the mediation. He's saying it's premature.
My argument was basically we've exchanged discovery. We were seeking to schedule depositions, but I'd rather not take those depositions unless absolutely necessary for trial, so I'd like to do it after mediation.
Okay.
I know the other side has not sought out any other discovery in any way.
Well, can we do some discovery? Why don't we do this? Why don't we do some discovery before the mediation?
Well, I mean, we've already exchanged discovery in counsel. I mean, the defendant hasn't done anything else, so I just assume they would.
What else do you need before mediation?
Move forward.
The motion is premature, Judge. Just so you know, the case was answered in May of 2018. We asked for the deposition of the plaintiff in August. We found out the plaintiff was incapacitated.
Okay.
In December of this year, they substituted a party. I don't even have the plaintiff's deposition.
Yeah, they need to take the plaintiff's deposition before they can meaningfully mediate.
Okay, well, I mean, we can make that happen at any time. I mean,
Why don't we do this then? Why don't we let's require mediation within 120 days then, but in the meantime, defense can do whatever discovery they need to do. So the motion to compel is granted, mediation within 120 days, and defense can do any additional discovery they need to in advance of the mediation.
and we will cooperate with them fully to make that happen for you.
Great, okay, sounds great. Just email the order. Thank you, guys.
Thank you.
All right, what case you on?
I apologize, Your Honor.
Which one?
I have 3 CMCs that I must know.
Which one?
Caracuso.
Judge Caracusa does criminal.
Yeah.
You were with Caracusa? Oh, yeah, you were there. Okay, that's fine. Oh, which one?
It was, let's see, Bank of America versus O'Neill.
O'Neill, okay, hold on, I gotta find it on my list, hold on just a second. Bank of America, O'Neill.
I think you dismissed that one.
I did, yeah, that's when you weren't, Mrs. O'Neill was here and you weren't here, so the case was dismissed, you're gonna have to take it up with him. You gotta be here.
I
know,
literally, she took the bench lead.
I'm so sorry, but the defendant pro se was here, so you
Okay.
got, that case was dismissed, you're gonna have to
Lone
discuss.
Depot versus Carlos Ramirez.
Okay, hold on just a second.
Number 7.
Number 7, yeah, that's one, that one was a no-show as well, so that's fine then. What's the status of that case?
The status was it's on the lost mid-fall. Defendant filed a motion to be removed from the case. We emailed her a joint skip. She hasn't gotten it back yet.
Okay, that's fine, I'll do 90-day CMC on that one.
And then last one is Partners for Payment Relief.
Okay, yeah, what's the status of that one?
That one OC recently withdrew. Defendant said they're looking for new counsel. We filed out a renewed MSJ.
File the MSJ within 45 days.
Okay.
Okay, perfect, all right, thank you so much. All right, what case you're on, counsel?
Judge, I actually have a couple, I was here for, I checked in first
Yeah.
thing this morning for the CMCs, I was 32 and 36.
Okay, that's fine.
I ran downstairs for a second, I came back and the person was walking out as I was walking back in.
Yeah, because we move fast.
I was like calculating in my head, I was like, 9:01, Judge Harrison was gonna come in, and like, I was 36, so like 30 seconds of CMC, I can run back up here.
Okay, that's fine, all right. You're lucky I'm doing this. So what's the status of 32?
Okay, number 32, I believe is an issue. There's numerous defendants in the case. I ran through everything.
Okay, that's fine, I can set it for trial. When do you want to go to trial? How much time for the trial?
Some maybe an hour.
Okay, so I'm going to set for trial within 45 days.
That's for 32. I think you may have dismissed it, so I want to
I
make.
have, no, I'm going to make
Thank
sure.
you so much.
Trial within 45 days.
And I'll tell you, you tell me. the
Okay, got it. And what's in it, 36, right?
Yeah, number 36 is Freedom Mortgage versus Everett. Judge, this is, I cross-noticed a motion for default. The only party remaining is Richard Everett. He filed a motion for extension of time.
I'm going to grant his motion for
No,
extension.
You already granted it
Okay.
in November. He never filed anything. We cross-noticed, he never filed it. I
Okay.
cross-noticed a motion for default.
But I can't grant a default then if he filed a motion. I mean, he did. I
No,
can't
you
grant
went
a
to
default.
court
That's fine.
last
I'm going to grant the
CMC.
default. Let me grant the default then.
I
That's
have
fine.
the paperwork with me.
That's fine. I'm going to grant the default then.
Okay.
And then let's indicate that it shall be set for summary judgment within 45 days.
Do you want to set it for trial too? Whatever.
Yeah, let me set it for trial within 45 days.
Just so clear that at the last CMC, November 13th, the MPT was granted 10 days to file a response.
Yeah, so I'm going to grant the default and then I'll set for trial within 45 days.
So I should give the motion of proposed order
Yep, to the bill. Yep.
Thank you, Norris.
All right, thank you so much. Anybody else here from UMC? And we're going to go ahead and give Mr. Bannick her, or which case you're on?
Yes, Your Honor. Matter of Bay Beach versus Dorsey. I submitted, this is a Judge Curley matter.
Okay.
I submitted a proposed decree in order.
Oh, you'll get that by email.
Very good, Your Honor.
Thank you. Have a great day. Can you make sure Mr. Bannick gets her stuff and we're good to go? Thank you so much.